Hi everyone and a very good day. My name is Nursara Devi Chandrika. My metric number is 73808. So right now, I am going to present or going to talk about a topic which I have chosen for my individual assignment. So my chosen topic is striking out. Before we go into striking out, we shall know the things that is before striking out. So we know that when an individual wants to take a civil action against another individual, so the first step must begin with pleadings. So pleadings are a type of formal documents filed by each party in an action which state the party's basic positions, such as what is his claim, dispute or argument will be at the trial. And also pleading consists of statement of claim, defense, counterclaim and defense to the counterclaim itself. However, the party can apply to the court the opponent's pleading or the plaintiff endorsement on the under Order 18 Rule 19 of the Rules of Court 2012. So, based on Order 18 Rule 19, it stated that the court has the discretion to strike out any pleading or endorsement of the writ at any stage of its proceedings. Besides that, the court also given inherent jurisdiction to Order 92 Rule 4 to make an order to strike out a pleading in order to safeguard the interest of justice of the party. And Rules of Court did not specify the specific time for the party to make an application to strike out the pleadings, but applying to the case of Jamir Hassan against Kang Min, the court stated that an application to strike out a pleading should be made as soon as possible. So it is better to apply before the close of pleading and will probably be rejected where the matter has been set down for trial. So it has to be made as soon as possible. Moving on to the ground which the court will consider to strike out the pleadings made by any of the parties. So in Order 18 Rule 19, it has laid down the grounds that the court could strike out the pleadings. So the first ground is the pleadings. It can be struck out if the pleading has disclosed no reasonable cause or action or defense. Second, the pleadings itself may be scandalous, vexatious or frivolous. 3. It may be prejudice, embarrass or delay the fail of trial. And also 4, which is the last one, it may be an abuse of the process of the court itself. So, after assessing whether the content of the pleadings contain such grounds mentioned just now, the court may order for the action either to be stayed or dismissed or judgment to be entered direct. Looking at the case of Lim Piao alias Lim Neo against Perwira Habib Bank Malaysia Berhad, so the court stated that the principle under Order 18 Rule 19(1) was well settled because the court has the discretion and has the power to exercise its discretion based on the four limbs to determine whether a pleading should be struck out or not. So this case had been followed widely based on the principles stated under the case of Bandar Builders Sdn Berhad against United Malayan Banking Corporation Berhad. So in short, the principle under the Bandar Builders Sdn case Berhad was clear that the court should order for a striking out when the case was obviously unsustainable. We can refer to the case of Sim Kui Chun against Superintendent of Pudu Prison. So where the court held that the principle governing the striking out of pleading is that the claim itself should be struck out only in plain and obvious, which the court can say that the claim was unable to sufficiently stand alone. Without any further delay, so now we're moving on to the first ground, which is no reasonable cause of action or defense. So the defendant itself must show that the plaintiff's statement of claim consists of no reasonable cause of action or defense. Mere fact stating that the case was weak was a ground for the court to order for striking out for an action, as long as the statement of claim of the plaintiff discloses some cause of action. The court will order for striking out. Reference can be made in the case of Taib bin Awang against Muhammad bin Abdullah, where the court struck out the plaintiff's action on the ground that the plaintiff had no cause of action as the appeal against his conviction was still impending. So we can also see in the case of Law against Liu Win, where the plaintiff sued the judge who made the bad remark on him. The court held that the plaintiff has no cause of action as the judge was immune, thus the action was struck out. Moving on to the second ground, which is the pleading may be scandalous or so the court may order to strike out an action when the party make a derogatory remarks or use abusive language to their opponent. We can refer to the case of Pertamina against Kartika Ratna Tahir, where the court struck out the plaintiff's defense on the ground that the plaintiff had made a scandalous statement. Moving on to the third ground, which is the pleading may be prejudicial or delays fair trial. So the court will or have the power to strike out an action which are prejudicial and unjust, where the purpose of it is only to delay. So if a pleading is unnecessarily and tends to be prejudiced and delay the trial, then it offends the rules of pleading and does not inform the other party for the case. So however, in the case of Ong Lynch Sim against Teo Kahin, the plaintiff applies under Order 18 Rule 19(1) to strike out the defense on the ground that the defendant tends to delay the fair trial of the action. So the court held that the delay of more than 1 year to file the application was not fatal to strike out the defense and counterclaim. So it means that whether the pleading may be struck out on the grounds of prejudicial or delays fair trial, it must also be taken look at the time within the time limit itself. So that's on the pleadings is prejudicial and or delays a fair trial. Moving on to the fourth round, which is abuse of process of the court itself. So for the abuse of process, a civil suit may be struck out by the court when there is an element of the process of court under Rule 18, Rule 19, or the 18 Rule 19 1D of the Rules ROC 2012. Abuse of process of the court refers to a situation whereby the court's process is manipulated for unlawful means and not for actual purpose intending to achieve justice. The term of abuse of the process of court in Order 18 Rule 19(1) D of the ROC 2012 can be defined in the case of Gabriel Peter and partners against Wee Chong Jin and others. So the court held that if an action was not brought bona fide for the purpose of obtaining a relief, but for some ulterior purpose, the court had the power to strike out the pleading as an abuse of the process of the court. So that's on the abuse of process of court. It must be known that the categories for rendering a claim for an abuse of process are very, very wide and depend on the relevant circumstances of the case itself. There are several cases that the court will strike out the party claim when there is an abuse of the process of the court. In this case, the plaintiff had previously filed an identical claim against the defendant by way of Suit 103. However, the Suit 103 was struck out due to non-compliance with Order 34 of the Rules of Court 2012. The plaintiff did not make an appeal against that decision. The defendant argued that there was an abuse of process of court, as the plaintiff could have appealed against the decision of the court and not by filing another identical suit on the 18th of July. So the court struck out that the statement of claim and held that the filing of Suit 303 was definitely an abuse of process of the court. The plaintiff should appeal or apply to set aside the decision and not by the way of filing another identical suit. Such action could be seen as an attempt to circumvent the necessary appeal procedure or an attempt to circumvent the procedure for setting aside the decision in Suit 103. So, other than that, looking at the case of Dato' Ahmad Johari bin Tun Abdul Razak against Santanil Selvi, anak perempuan Alau Malay. So the court strike out the present suit filed by the plaintiff on the ground that it was an abuse of process of the court. The court then held that the suit was no more than a reception of an earlier suit, so which bear the same fact, cause of action, and also relief. We can refer to the case of Mayben Allied Berhide against Kenneth Godfrey. So, in this case, the court held that to allow the appellant to file the second suit, which had the same fact, was unjust and prejudicial, and to the respondent, particularly when the counterclaim against the appellant had been withdrawn by the respondent itself. Therefore, the court ordered to strike out the second suit under Order 18 Rule 19 as the second suit was clearly without merit. to exercise his inherent jurisdiction to make any necessary to make any order that is he thinks necessary to prevent injustice or abuse of the process of the court. So the court can order the action to be stayed, dismissed, or to judgment to be entered. So reference can be made in the case of Penang Port Commission, where the court could exercise its power under the inherent jurisdiction to terminate a proceeding which was found to be an abuse of a process of the court. The inherent jurisdiction was to be exercised judicially by the court in order to safeguard the party from being prejudicial. Okay, so right now I am going to recap a little bit on what have I just presented just now. So the first one, I gave a brief introduction of what is actually pleadings and how important it is to be as the first step of everything that we discussed today. So without pleadings, there is no striking out, obviously. So after telling on the pleadings itself, I move on to the grounds of pleading stated under Order 18 Rule 19 of the Rules of Court 2012. I explained one by one according to the sequence stated in the ROC 2012, also with the case law as an example. So example and illustration. So with that, I would like to conclude my presentation until here. I hope that my presentation was clear and also beneficial to any of you. So with that, thank you so much. Assalamualaikum and have a good day.